3 to 6%. That was how much the average estate planning expenses cost if you have to go through probate. Was just talking about this with one of our estate planning attorneys on the radio just the other week. And again, if you have an estate, think about that, 3 to 6%. You could lose that in just fees of paying some attorney to have to put your estate through probate if you don't have a plan. That's why today on estate planning, we're going to talk about the principles of preserving wealth so that you don't have to have that large expense associated with probating your estate. I'm Matt Goolsby, and I'm going to be taking you through today's class when we're talking about estate planning. Got to get the disclosures out of the way. None of this is intended to be legal or tax advice. Contact a legal or tax professional with discussing what's going on in your situation, because everyone's situation is a little different, right? And we'll talk about throughout the class here today where you can come in or meet with us virtually to talk about your unique situation. So we're a firm called Market Advisor Group. So if you want to find more webinars, you can go to marketadvisorgroup.com, click that classes tab, and watch all the different topics we have there in our available library. When I'm meeting with people, because I'm a financial advisor, I'm not an estate planning attorney, but oftentimes when I'm meeting with people, I'll hear some common themes or sometimes some common questions that come out of that group. And sometimes we don't get there in time to help them avoid these costly mistakes. So we're going to share with you some of the common mistakes and questions that we get in the conference room. One of them is, well, Matt, I don't need a plan. The state has one for me. And that's true. If you do not have any kind of written formalized estate plan, the state in which you have stuff, whether it's you have rental properties or bank accounts or your personal residence, each state that you have stuff in has to go through its own probate case per state, all right? Now, if you don't have a plan, the state has an order of succession, if you will, where they divvy up the assets, but you don't want to go that route, because if the asset is not titled correctly, or if again, the expense of probating an estate from 3 to 6%, you don't want to have that. So at least have a formal written plan, because the majority of Americans do not have even the basics, a will. Another concern we'll oftentimes see, or even a mistake sometimes we'll see people make, is when they have these blended families. Blended families, they are where you've had previous relationships, maybe you've had children with someone else and you've been remarried, whether due to the death or loss of a spouse or divorce. And you want to make sure you take extra care there, because if you don't structure it correctly, maybe you would be disinheriting the surviving spouse. I'll tell you, my parents, they've divorced and they've remarried. And when my mother remarried my stepfather, Ted, my mother was not originally on the deed of Ted's house. And I told my mother, if you don't have an estate plan, Mom, or if Ted doesn't have an estate plan, since the house is only in Ted's name, if he passes away, yes, it will go to his spouse, which is you, but half of it will also go to his daughters. So that's why you need a formal estate plan if you're working with blended families. Oftentimes you can mistakenly disinherit someone. When a trust just isn't enough, who could you disinherit unintentionally? This is sometimes where people will come in and they'll say, well, I want a trust because so-and-so had a trust and that worked. Maybe you need a trust, maybe you don't. Not everyone needs a trust. But oftentimes, if a trust is in place, there's other documents you may need to help people help you with the last days of your life, number one. But number two, a trust, if not written correctly, you could be disinheriting future lineage, future heirs, future lineage of your family. When you're powerless, what it can cost you, this is really an important one. I'll have a story that I can share with you on this, where someone did not have the correct documents for an emergency that came up, and it cost them dearly, almost $300,000. And most of the time, people that are specifically married, they'll think, well, I can sign for my spouse. Oftentimes not the case. Unless it's a joint account or you guys have joint tenancy, you need a legal document that allows you to sign on your spouse's behalf when maybe they're incapacitated or unconscious. How much would you like to leave to the government? What I mean by this is oftentimes most estate planning does not take into any account tax planning. And when I say tax planning, I'm specifically referencing those IRAs, 401ks. If you have large retirement accounts that have never had the taxes paid on them, one day someone's going to pay the taxes on those retirement accounts. Most estate planning does not address these tax bombs that have become your IRA and your 401k. And if you leave that to your surviving spouse, yes, they can take that over their lifetime. But when you leave it to a child, the rules have changed with the Secure Act, and we'll cover what that is today. Why financial advisors can't help you with Medicaid planning. Oftentimes, if you want to do Medicaid planning, it's highly recommended to make sure you involve an attorney because it is a very complicated process. And if you try to move things out of your estate or out of your possession to qualify for Medicaid, if you don't do it in a way that passes their sniff test, so to speak, you could be hurting yourself gravely. And we'll talk about there's some things you can do to protect at least your house. Oftentimes, if it's paid off, it's easier, but there's things you can do to protect your personal residence, but you have to do it 5 years before you would ever even look at needing a claim. And we'll talk about that today as well. Will taxes be the biggest retirement risk you haven't planned for? I would say probably so. The top 2 concerns I have for your generation, for the demographics that are nearing retirement or already in retirement, I think the top 2 issues are inflation and taxes. Inflation because we've printed so much money and there's still so much money out there, and we don't seem to be slowing down on our spending too much on the federal government. And then taxes are coming down, so that means we're going to borrow more if we can't find the spending cuts in our government. So inflation and taxes are the 2 biggest risks. And if you're not looking at tax planning, probably in particular with those retirement accounts, one day there's going to be a tab due on the taxes on those accounts. And you might want to look at ways you can maybe offset that huge tax bill in the future. There's different strategies for different people. Probably the number 1 concern I get from people when talking about estate planning or having questions around what estate plan is best for them is they do not want to be a burden to their family they leave behind, or primarily maybe the children. You know, I don't want to be a burden to my child. I don't want to have to move in with them. I don't want them to have to take care of me. And truth be told, your kids probably don't want that either. But if you don't have plans in place, it's oftentimes a scenario that you risk if, again, you haven't put any of these pre-planning ideas together, what we're going to cover today. We're going to talk about several stories that we've come across as a firm. I always will joke, it's kind of like that TV show you watched growing up, right? The following of what you're about to see is true. The names have been changed to protect the innocent. That Dragnet show growing up, where they would talk about real stories, but they would write them in ways where you could understand them, but it protected their identity. We're going to do that today. I'm going to have several examples talking about scenarios that we've seen where disaster struck because the plan wasn't correctly in place. The majority of Americans do not have a will. Depends on which study you see, but over more than half, right? And a will is among the basics of your estate plan. It's written instructions to the court on how to divvy up your stuff. So let's talk about what some of the things the will does. A will names an executor. So that's someone that's going to represent you through this process when you're not here. Also, you can name a guardian for minor children in a will. So maybe you have a will that's from a long time ago when your kids were little and now they've grown up. Might be time to update that will. But if you have again minor children, it might be a good idea still to list out who would maybe take care of them. I have some clients that have grandchildren, legal custody of their grandchildren, and they're not 18 yet. So in that will, you might want to list out who would raise them. But the primary purpose of a will is it's written instructions to the probate court on how to divvy up your stuff. But for a will to be valid, it's going to have to be probated. It's going to have to go through that court process and be recognized by the court. And at minimum, probate is a 6-month process. You don't really want to wish that on anyone, okay? And it has to go through probate to be valid, to be recognized. And if you don't have a will, the state in which you reside has an order of succession which they'll divvy up the assets. And it might not necessarily be the case of how you want it divvied up. This is, again, a story. It was something we had a part in, but we arrived too late, truth be told. And this is a gentleman, we're going to call him Blake. Blake, he was single and never married, had no kids. It didn't really concern him with estate planning because, again, he was never married and had no kids. But when he passed away, he had no estate plan. He had about $500,000 in his 401k at work with no beneficiary on there and, again, no formal estate plan. Now, I met his brother. We're going to call him Stephen. And Steve was coming in thinking he was going to be beneficiary, or somehow maybe his brother's account would go to him, surely. But there's an important detail here. His mother, she was in a nursing home, and she had basically spent all her money on her care, and now Medicaid was caring for her. So Blake's parents, Blake and Steve's parents, they had already spent all their money on their care, then had to sell the home, use all that money. Medicaid spend down took his mom's assets down to $2,000. But since there was no estate plan here, when his 401k was going through probate, it would go to his mother, which wasn't very beneficial for their mom because, again, she was on Medicaid, and now that retirement account, which could have benefited his brother, didn't go to Steve. It was going now to pay for mom's care. All this happened because, again, there was no estate plan in place. And the order of succession says if you're not married and your parents are alive, again, your parents are the rightful heirs. And it messes a lot of things up when you don't have this formal plan in place. So now when you're powerless, what it can cost you, and this is in reference to power of attorney documents. And if you don't have these documents in place, even a simple situation, or what you'd think could be a simple situation of being in the hospital and having to do some business for your spouse, you need a different document than your marriage certificate to help you be signing or having signing authority for your spouse when they're unconscious or they can't sign on their own behalf. That would be a financial power of attorney for finances. Now, this is a story about Kim and Tom. Tom, he was offered a pension buyout. So instead of taking that monthly income stream in retirement, they would give him $350,000 if he rolled that out and put it into his IRA. Now, this was going to be beneficial for Tom and Kim's situation because the detail I haven't shared with you yet is Tom, he is actually terminally ill. He was in the hospital. He'd had a very aggressive cancer, and his wife was caring for Tom. Well, Tom had signed this first pension packet saying they wanted to go ahead and take the money and have it rolled into his IRA because that would benefit Kim, because if he passed away, that money could be very beneficial for her in retirement. As Tom continued to decline, Kim, his wife, had concerns. She wanted to reach out to the pension company and find out what would happen if Tom passed away before this money would arrive. And there was a second packet that actually Tom needed to sign, and Kim was wondering, well, could she sign it? So she called the pension company, and they would not talk to her. This is Tom's pension. It's not Tom and Kim's pension, even though it would be that way if they needed to take it as income, but it's different. Tom was in a state where he could not communicate his needs to this pension company, so his wife was trying, and since she didn't have a financial power of attorney, Kim was powerless in this moment. Now, one of our attorneys drafted one up, went to the hospital, tried to get Tom to sign it, but realized Tom was so far gone with hospice, he was not aware of his surroundings, so he was not of sound body and mind to sign his rights over in a POA. So the backup step was to try for a court order, but time ran out, and so instead of getting $350,000, I think it was around $50,000 what went to Kim, and that cost her greatly. You want to make sure you have a financial, medical power of attorney in place for when these disasters strike, so you can have people you trust to make decisions on your behalf when you cannot. So let's review some of these documents we've been talking about. A will is written instructions of how to dispose of your assets, and that's written instructions to the probate court, right? A power of attorney for finances. Well, that authorizes someone to make legal and financial decisions on your behalf in case of an emergency. A trust. We haven't talked about them, so let's talk now about what does a trust do. Well, a trust enables the transfer of assets without going through probate, okay? Sometimes even the trust can hold on to assets. You can do a lot of different things with a trust. So let's talk about an example here of sometimes a typical example of when you would want a trust. So this is a client, a couple that I work with. We're going to call them Ron and Deb. They both have had previous marriages. Now, Ron didn't have any children, but Deb does. Deb has 2 daughters. And her father had passed away several years prior to me meeting them, and he had left Deb, his daughter, $300,000 in oil stocks because her dad was in the oil industry and that was his profession. So Deb had thought, if I get this inheritance from my dad, which they had, and they want to make sure it stays in Deb's family. So if something happens to Deb, her and Ron had thought they had drafted up a trust with an attorney to do this, but it turns out that really wasn't the case. See, if she passed away, like I said, she wanted these $300,000 or maybe whatever was left of it over her lifetime to go to her daughters and stay in her father's family. Okay? Well, this trust that they thought they had that did this actually didn't do that. It said all assets went to Ron, her husband. And I think because the financial advisor sends people off and refers people off to attorneys and says, I have this person you can go talk to. They take good care of my clients. I think it's because when the clients have to relay all the information to the different professionals, it allows for a lot of things to fall between the cracks. In other words, it makes you the responsible party to relay all the information between all the professionals helping you. And I caught this on our onboarding process, going through our report process, that's the retirement evaluation process, other risks, and taxes. Well, this is a risk. Do you have the right estate plan for your situation? So because the advisor and the attorney were basically disconnected, or in other words, the responsibility was on Deb and Ron's shoulders to relay all this information and update the beneficiaries and make sure it does what Deb does, or Deb wanted it to do, it was on their shoulders, and they had missed it because they're just living life, and that's not a surprise, right? So what would happen, though, here in this situation if Ron remarries and the trust was never corrected? Would Ron probably give that money to the daughters? I would think he would, but let me throw in some what ifs, because this is what mainly estate planning does, is it tries to close these what if loopholes or help stop chaos in the future. What if Ron would remarry and then that new spouse either has debt and they want to try and use that $300,000 to pay it off, or they've always wanted a condo or a place in Florida, or whatever the excuse is? It puts Ron in a very tough situation, because if he now inherits this $300,000, which Deb originally wanted to go to her girls, and someone's already in his ear swooning him and wanting to be his partner or even spouse, you don't want to put Ron in that tough situation. So you want to make sure you have these things spelled out correctly. So this is a story of someone that actually works with my father. My father is another advisor with our firm. I'm going to call this the untrustworthy son-in-law. And I think it was around Christmas or Thanksgiving where this gentleman popped off and said something, well, one day when all this is mine, and it just didn't really set well with Mama Bear, who was my dad's client. So this is a story about someone we're going to call Faith and Tom. They have one daughter. We're going to call her Cindy. Now, Faith and Tom, they had mentioned to my father, their financial advisor, that they had some concerns with Cindy's spouse. If they were to pass away and leave this $1 million, would there be anything that was protecting it from potentially Cindy's spouse in the future divorcing her and maybe losing half of that in the divorce? And my father, being a financial advisor, he doesn't know the answer. He's not an attorney. He doesn't practice in this realm. So he walked down the hall and grabbed, I believe it was Gerald, one of our estate planning attorneys with Eidelman Law Firm. And they continued this conversation that they were having in real time. My father, their advisor, didn't have to send them somewhere else. He didn't put it back on their shoulders. They could work on this problem together, or this concern that Mom had about the inheritance for her daughter together. So the financial advisor worked with our estate planning attorney to create a trust. And this trust says upon Mom and Dad's passing, the $1 million goes into this trust, and Cindy doesn't have ownership of it. But she could benefit from this trust, but the spouse doesn't have any legal claim to it as long as the assets the trust buys stay in the trust's name. And the trust spells out something like, 30 or 40% of the trust can be used to go buy a home if Cindy wants to do that, but the trust has to own the home. And the trust owns that home. It doesn't put anything in the daughter's name, so that the daughter can benefit from this, and it protects her from losing it in a divorce or losing it just to frivolous spending. And this is a worst case scenario probably. This is oftentimes what some people have concerns with. I don't want someone to inherit all this money all at once, or I don't think this person's used to a lot of money. Maybe we need to make sure they have some protections. One of our estate planning attorneys in Eidelman Law Firm calls them creative spenders, because the typical inheritance, it's gone in a matter of 90 to 120 days typically. And if you have people that are not very good with money, they could hurt themselves. So this is a case where you could design a trust that could protect the daughter and basically control some spending from beyond the grave. So this is what I'm talking about, this disconnect that can oftentimes happen if people are not working together. Maybe you have an advisor, you go to them and you ask questions of them, but if they're not an attorney, if they're not a tax advisor, they oftentimes refer you other places, right? Well, I can't really answer, do you need a will or a trust? Or I can't really help you figure out those decisions because I'm not an attorney. But hey, here's someone takes a card out of their desk or their pocket. This is someone I refer a lot of people to. Go see them. And maybe then you take the time to set the appointment. You go have that with the attorney. They talk about your situation. You have to relay any details from your financial situation to the attorney. Maybe you're doing it all correctly, maybe you're not. The attorney then drafts up your pretty papers, mails them to you for you to review, and then you sign them, and then you have your pretty estate planning papers. But now what? Should you maybe go back and update some of your beneficiaries? Do you maybe need to go back and retitle some accounts? Should there be things that if you have a trust now, should the trust be the ownership? There's a lot of loose ends left here when you get your plan that maybe you need to go back and do some things there. Maybe you do, maybe you don't. But when you find yourself back there, that financial advisor, then you ask tax questions. Well, the estate planning attorney, they didn't really have any tax considerations to how to offset these taxes and mitigate it. I mean, what should we do? And then the process starts all over again. And I ask you, if you're not getting tax advice before you start Social Security, before you take that withdrawal out of your retirement account, before you start that pension, before you sell that rental property, whatever the tax advice that goes around the incident where you need it, if you're not getting that advice before you take that action, it's out of your control. You're going to owe whatever it ends up being when the taxes are filed, right? If you don't know what that dollar amount is, how did you arrive at your decision? Did you have tax advice before you took that withdrawal? Did you have tax advice before you started Social Security? Most of the time people overlook that, and I'm telling you, it's worth just as much as the financial advising, but I think the financial advising gets all the attention when really the tax advising is just as equally important as the financial advice. And if you're working in this kind of setup here, I would ask the question of who's working for who, because you've hired three different people or multiple people to help you with your plan, but you're the one that's running all over town doing all the work. And you're the one that's running all over town, spending your time relaying all the information, hopefully correctly. So if you had a place where if there was under one roof, you had all these professionals working together, it changes the dynamic. It allows for real-time conversations, and it allows for those team members to coordinate and be efficient on your behalf so that you're not the one having to go out and relay all those informations and having multiple meetings and just inviting for something to fall through the cracks because of, again, all the disconnected chaos that's out there. But under one roof allows for real-time answers and coordination. And that's what we do as a team here every day. When you start planning which plan is maybe best for you, or how do you start the planning process, is you want to take an inventory of your assets. Do you have rental property? Do you have a family business? If that's the case, you have even probably an extra layer of estate planning we need to look at. Or maybe if you just got your personal residence and your retirement account and maybe some personal family heirlooms, you need to take an inventory of all these assets that you have. And then once you've gathered that inventory, then you want to think about what are your objectives? What are you trying to do? Do you want to avoid probate? Do you want to keep peace and harmony in your family when that day comes that you're passing away and divvying up all the stuff? Do you want to control spending from beyond the grave? There's so many different what ifs, and what's important to some people is not important to others. So when you're thinking about the estate plan, after gathering the inventory of those assets, think about what are your objectives? What are you trying to accomplish? There's parts of your estate plan, though, that most times I think get overlooked. And if you're overlooking them, you have gaps in your estate plan. The ones that get all the attention is the will or a trust. Well, I've got a will, I've got a trust, and that's the part of that kicks in after your death. But during your lifetime, again, there's different estate planning documents that help you control or help you determine the last days of your life. So let's talk about what some of those are. And some of these documents and some of these advanced healthcare arrangements or agreements, they help keep harmony in your family. Take this example, for example. This is Sarah and Brian. They couldn't agree with what was going on with their mom's healthcare. Their mom was single. Her name, we're going to call her Stephanie in this example. Brian had said, I talked with mom. She was adamant her whole life. She did not want to be kept on a machine, right? Well, Sarah, the sister, the daughter of Stephanie, she had heard one of the doctors say something like, well, there's a very small chance your mom could make it. And Sarah was clinging to that phrase, that small chance. And she did not want to take on the mental or emotional baggage of literally pulling the plug on her mother, her parent. So see, Stephanie, she only had a basic will. And at least she had that. But she had not had any healthcare arrangements, any instructions provided for her kids, and it put the brother and sister in a very tough, uncomfortable, and emotional situation. There are some healthcare documents that you can have to help avoid these catastrophes. So let's talk about what a living will is. Well, a living will provides specific instructions about your end-of-life care. I'm sure you can recall it was about 20 or 25 years ago. It was a big case. I believe it was in Florida, the Terry Schiavo case. Do you remember that, where she was in a hospital bed and she was on a feeding tube and her husband wanted to pull the machines off so she'd pass away, but her mother and father did not. And that went all the way to the Supreme Court. So you probably don't want that happening with your family. So make sure you have these specific instructions about your end-of-life care. A DNR would be a do not resuscitate order. Now, typically that's not something that we're encouraging for people that still hopefully have a lot of years left in retirement and plenty of life left to live. A DNR would be mostly required if you were going into a nursing home or a skilled medical facility or maybe even hospice, where you have to pretty much say, hey, I know when I go, I don't want people shocking me, or I don't want those paddles, or I don't want to be brought back to life. That's what a DNR is. So we don't normally recommend those for people that are healthy because we want you to, again, live. But another power of attorney you need to have is one for healthcare. So there's different power of attorneys that do different functions. You don't normally have a blanket power of attorney. It has to spell out what power that is. And a power of attorney for healthcare, that authorizes someone to make healthcare decisions on your behalf. And the litigious world we live in, the world we're all worried about attorneys suing for this, that, and the other, it's very important that if you have a power of attorney for healthcare, it includes what's called a HIPAA release. And HIPAA, I think, stands for Health Information Privacy and Portability Act. So that protects your health information, that HIPAA release. But if you don't have that HIPAA release inside your power of attorney for medical, then it might cause some issues with the facility, hospital, doctors, and nurses. You want to make sure that language is in there. Releasing that facility or professional, the doctor or nurse, it releases the liability and it says, hey, this person that I've made or authorized to make decisions on my behalf for my health care, I've given them also this HIPAA release as well. You can release my information to them so, they can make an educated decision on your health. So you want to make sure your estate can avoid probate, because I mentioned at the beginning of this class, probate can cost anywhere from 3 to 6%. That was just when I was talking with one of our estate planning attorneys the other day. That's typically the fee range. So if you have $1 million or a $2 million estate, you're looking anywhere from $30 to $60 to maybe even $120,000 in legal bills. And you can totally avoid that with having the correct estate plan for your situation. Now, this is someone that had a bunch of rental properties. And I'm not sure if you caught this earlier in the class, but I mentioned that each state in which you have stuff, you either have to, when you pass away, and if you only have a will, or if you don't have a will, there has to be a probate case opened in each one of those states. Maybe a different way or more beneficial way to say it is if you have rental properties in different states and you only have a basic will, like we're going to talk about Doug here, then you could be opening yourself up to having a probate case in court case in each state where you have all your rentals or your properties or whatever. And this is why it's so beneficial to work together as a team. Because I'm pretty sure this was caught during Doug's Medicare review for his prescription drug plans. And one of our Medicare advisors, or I think it was Trey Bossa specifically, had heard Doug say, well, I've got this estate plan already in place. It's a will, and then I have all these properties in 5 different states. And I think Trey had heard from either watching this class or just, again, working together as this team. He recommended to Doug, you probably want to go talk with one of our estate planning attorneys, because I don't think this does what you think it does. Well, Doug, again, with these several rental properties in, let's call it 5 different states, I think it was Florida, Missouri, Kansas, Oklahoma, and Texas. And had he only had this basic will, a probate case would have been having to open in each one of those states to transfer these rentals out of his name and to whoever he had them being divvied up to in the will. Well, that could cost a lot of money, right? So if he passed away, and the kids would have had to, again, open up all these probate cases in each state. But the better way to probably handle this situation, because one son had always told his dad, I want to sell, I want to sell, I want to sell. And Doug had been worried about this kid because this kid has not been very good with money. Doug had concerns if this kid got the money all at once, what would happen? Well, 2 of the other kids, there's 3 total, they had told their dad for years, well, we want to run this as a family business. We want to continue this legacy on and run this, but one of those siblings wanted to cash out. So they created this trust that would avoid probate from having to be open in every state, because if the trust were to be, instead of the will, if the houses were to be transferred into the trust upon Doug's passing, the trust could hold on to them. And if one child wanted to cash out, the trust had instructions on how to buy that sibling out and create more of an income stream for that kid versus a lump sum money all at once. Because again, sometimes people that are not used to having money, or maybe they're not good with money, if they get a large inheritance all at once, they can hurt themselves. So this trust allowed to set up for a lot more harmony, where you didn't have all the expense of the probate cases from each state. And furthermore, it helped the son that wanted to cash out and wasn't great with funds or managing his own money. It didn't allow him to hurt himself all at once. So this was a great example where a trust was better for Doug and Doug's family than having just that basic will. So probate avoidance devices. There's different ways you can avoid probate besides a trust. Now, you can't control any spending from beyond the grave. It's not going to protect your house from Medicaid spend down. There's all these other different probate avoidance devices, but they don't offer any other benefits. And sometimes you don't need those other benefits in your situation. In Kansas, there's something called transfer on death. So that's where you can title an asset. Typically, it's a real estate, like a house. You can go down to the county and register that as TOD, where if you want it to be your son or your daughter or your kids, all they have to do is go down to the county and present a death certificate, and it allows the transfer of that real estate asset to transfer to whoever you've designated to transfer on death to. Now, again, that's not going to protect from divorce or any other kind of calamity that comes along with that, but you do have this option to avoid probate, and this is the basic among basics. Sometimes people don't even have that. If you have a bank account, POD, or payable on death, would be what you'd want for that, or maybe a CD at the bank. But this oftentimes, again, while it avoids probate, it doesn't offer any protection for your kids or any kind of divorce or people that aren't good with money. And then oftentimes the most popular one is a beneficiary designation, and you'll normally have those available on your IRAs, your 401ks, sometimes any investment accounts as well. You can have those either with a beneficiary on them, or they're oftentimes listed as TOD or transfer on death. If you're over on the Missouri side, because we oftentimes serve the Kansas and the Missouri side, the transfer on death is called a beneficiary deed, but it functions the exact same way. So different states have different kind of rules. We mentioned that. Before I switch gears and talk about how the estate planning rules have changed for giving your kids your retirement accounts, or in other words, when you transfer your retirement accounts to someone you're not legally married to, before I switch gears there, I want to show you the tax history of the United States. And I want to show you that with the national debt and the top tax bracket by year by year. Now, when the income tax system came out in 1914, the highest highest tax bracket was 7%. Now, that's interesting because that 7%, that's lower, or that's beneath what the lowest tax bracket is today of 10%. And when the income tax system was introduced in 1914, the national debt that year was $3 billion with a B, okay? Now, of course, as time went on, taxes went up, right? But most people forget how high taxes were. And in the 40s, they went as high as 94%. And the national debt at the time was $200 billion with a B. Now, I would wager you're probably not in the top tax bracket, but the lowest tax bracket in 1944 was 23%. And the reason taxes had to go up was, well, at the end of the 20s, there was the Great Depression. The government put us all back to work, building roads, bridges, things like that. So that was a cost. And then World War II, right? So these tax rates had to go up to pay for all these things. Well, I find that history doesn't always necessarily repeat itself, but it oftentimes rhymes. And what I'm looking here at is I'm trying to look at history and say, hey, we've had higher tax rates in the history of the United States. We don't have any idea what high taxes are. We really don't. But if you have these accounts like IRAs, 401ks, I think high taxes could be coming, maybe not in the next 4 years under Trump's presidency because he wants to lower taxes. This could be an opportunity to maybe pay some taxes on that money that hasn't had the taxes paid on it, so you don't wind up in a situation like this in the future. Because the lowest tax bracket in 1944, it was 23%. And the lowest tax bracket today, again, is 10%. So if taxes have to go up to pay for all this money we've printed during COVID, to pay for the trade war, to pay for whatever's going on in the world, I think taxes could be higher in the future. And if you have these large retirement accounts, these IRAs, 401ks, there's strategies to unwind the taxes there. But you need to get working on it sooner than later, because the longer you put it off, sometimes the more expensive it gets. So of course, tax rates have come down over time, right? And the national debt has not. We've got a spending problem. They've changed the tax rates back in 2018, and it expires at the end of this year, 2025. And if they don't get together and agree on raising tax rates, or extending the tax cuts is probably the best way to say that. If they don't get together and extend these cuts, then the taxes are set to go up January 1st of 2026. We've been saying this for years now. It's an 8-year limited window. But back, if you look at in 2018, if you look at what the national debt was, it was $21.5 trillion. Now today, it's more like $36 trillion, and we're spending $2 trillion a year more than we're actually taking in as a federal government. So that's why they're looking at cuts. I mean, this spending is causing inflation. It's out of control. And if they don't get it under control, it's going to, again, be even worse in 4 years when the national debt is expected to be $51 trillion if they don't cut these spendings and they don't stop the spending as they are. $50 trillion. This is why I'm telling you your retirement accounts, they're at huge risk because you've not paid the taxes on them. So what is your strategy? Oftentimes when someone, if they're married and they lose a spouse, they get hit with higher taxes. I want to make sure you caught that. If you're married and one of you passes away, whoever survives will be paying more in taxes faster. Take the 2024 tax brackets here. If you're married filing joint, the top of the 12% tax bracket, it tops out at about $96,000. Well, if you lose your spouse and the next year you have to file a single for the 2024 tax brackets, the top of the 12% tax bracket for single filers is just half of that, $48,000. So if you still need $90,000 to live on, whether that's the income that's coming out of your retirement accounts, or you have to pull more money out of those retirement accounts because of the loss of a Social Security check in your household, if you still need $90,000 as a single person, you're up in the 22% tax bracket. This is oftentimes, again, when we see people make these mistakes where they put off taking money out of those retirement accounts until they lose a spouse, when really they should be looking at maybe Roth conversions or addressing some of the taxes on those untaxed accounts when they still have higher room in their tax brackets when they're married. Okay, this is a common mistake I'll see people overlook. They're almost doing it backwards. But again, I think that's because they're not getting tax advice with their whole retirement approach. So why financial advisors can't help you with Medicaid planning is typically because you need to get an attorney involved and make sure they know the rules about Medicaid planning, because if you don't, you can disinherit, or you can disqualify yourself is probably the better way to say it, not disinherit. But you want to make sure if you're moving those assets around, it passes the rules for Medicaid. Now, some people don't want to go that route, so they will just try and move their house out of their name. And that's a big risk. If you have your kids or your family member on your bank accounts, your cars, or your house, it opens you up to all kinds of liability because that asset then counts as theirs. So let's take this story about Susie, for example. Susie had thought, since she put her daughter on her home, basically taking Susie's name off the deed and putting her daughter's on there, it would be safe if Susie ever needed the nursing home, because Susie only had about $80,000 to her name and her retirement accounts. She didn't have a lot. Susie's son-in-law decides to divorce Susie's daughter. So that made the house an asset in this divorce, and it came into play. And there could have been ways this could have been avoided, but because it wasn't done correctly, Susie's intentions, they were good, but in the end, they were for nothing. And you don't want to try and move assets and do these games, because you play the risk of doing it in a way where either you'll lose it anyways, or it's not going to pass the rules of what Medicaid planning allows for. The big thing that I want to stress here is, if you have a financial advisor and they're meeting with you on a regular basis, they may not see all these issues, and maybe even if they do, if they see the other issues that you have in your situation, whether that's legal, tax, Medicare, Medicaid issues, they may not bring it up because they're not licensed to. But furthermore, if they're not licensed, they're not practicing in this area, they might not even know what risks to talk to you about that you have in your situation, because they're only dealing with the investments. So Medicaid planning, I mentioned this earlier, it's highly complicated, and I would encourage you to have an attorney involved working alongside your financial advisor, because if you need to move these assets out, or you want to maybe make sure you leave a legacy for your kids and not all of it goes to the care or the expense in the nursing home, there's things you can do, but you have to do it 5 years in advance before needing Medicaid, or in other words, 60 months, because they will look back and they will say, what have you done in this period? How have you moved assets out? Have you done it in a way that we approve of, or have you done it in a way we don't approve of? And if they don't approve of it, say you move $200,000, or your house is worth $200,000 and you try and sell it to your kid for $1. Well, that's a transfer of assets without, any value in exchange. So if that $200,000 was given away as that house, Medicaid would look at you and say, well, until you spend $200,000 on your care, we're not going to come in and cover you. So you don't want to find yourself in that situation either. And this is why, again, I encourage you guys to work with an estate planning attorney or an attorney that helps with Medicaid planning, because it is a very, very specific niche field. I'd encourage you to Google us. We have a weekly television show, Eye on Retirement. I know some of you guys watch that, and we appreciate you tuning in. That's a weekly show that we help people avoid the costly mistakes and some of these examples we come across doing this every day for a living. We also have a weekly radio show called Retire Hour. That's my baby. You can go to retirehour.com, check out past episodes, submit a question. But on that show, we talk about the ever-changing landscape that is retirement. And you never know what executive order is going to come out next, or what law they're going to change next. And most of the time, people find out after it hurts them, or after it costs them a bunch of money. And that's what we want to do on this program every week, is make sure that you're aware of what changes happen. We've written a couple books. One called The Investor Catch, talks about fees and risk and who's poised to profit more, you or your financial advisor. If you don't know what you're being charged in fees for your retirement investments or your retirement nest egg, I encourage you to find out. It's not uncommon for people to be paying 2%, 3%, 3.5% a year in fees. And most of the time, they're not getting that value in exchange for that fees. Specifically, when they're referring you out all these other professionals where you have to go do all the dirty work or all the heavy work and then bring back the information to the advisor. The Investor Catch is an easy read, about 100 pages. One of our estate planning attorneys wrote The Inheritance Trap, Common Estate Planning Mistakes and How to Avoid Them. They're available on Amazon, or again in our offices if you come in and chat with us. I talked about us as a group. We have tax advisors. Joshua Sikora, CPA, he's our lead tax advisor there with Market Tax Services, that we pull in the conference room all the time to get tax advice in real time for our clients. I mentioned Gerald Eidelman of Eidelman Law Firm. He's our lead estate planning attorney They're a great group to have because our clients are asking all the time of, do I need a will? Do I need a trust? So-and-so got divorced. Do I need to update my trust? There's all these questions that come up on a regular basis, and it's fantastic to have this team all working together. And finally, rounding out the Medicare group, we've got the Medicare or healthcare advisors rounding that out as well, because it's its own can of worms. So what's next? Well, I would encourage you guys to come in and take an hour of our time. We've set aside 60 minutes to get to know you, answer any questions you may have, go over anything and point out anything we may see, and it's always okay to tell us no and we can part as friends. But so many people actually ask us, what's the next step? Well, the next step is that second appointment where we go through our report process, where we look at our retirement evaluation process, other risks, and taxes. And that's where we do an in-depth examination of all the risks or maybe even any gaps you have in your current retirement plan. And then at the third appointment, we would make recommendations on how we'd address or handle those gaps and show you what our fee would be for managing your retirement and helping you with those situations. Most of the time, though, people only need that first appointment where they come in and they get answers to their questions or get a unique look at what's going on in their situation. But maybe you don't even need that. Maybe you just need to schedule a 15-minute call with us. You can do that. Those calls, we can take them any time of the day. But please, if you have questions, reach out, do something, because action or education without action is dead. And you want to make sure you're maximizing the things you need to do in your situation. Click the link below to schedule your 15-minute call or your in-person visit with us, or call 833-MAG-REPORT. That number again is 833, the letters MAG for Market Advisory Group Report. Or you can hop on again over to our website at marketadvisorygroup.com and schedule that chat with us there. Thanks for tuning in this week. Check out our other classes as well in our library. Thanks for tuning in.